whenever you are trying to acquire a company, which is a public listed company, the SEBI has a thing called the Takeover Code. Now, the idea behind the Takeover Code is to provide an exit opportunity to all the other shareholders of the company. The trigger. So the Takeover Code says that if you're trying to buy a company, then there is one trigger which is there, which is the initial trigger. So if I'm buying 25% or more of a company, that is the initial trigger, in which says that I am compelled to make an open offer, a mandatory open offer to the other shareholders of the company. The minimum size for that mandatory open offer to the other shareholders of the company is 26%. The idea is that if I'm doing 25, then 25 plus 26 means 51%. There's a change in control of the company. The idea again for that is that in a public company, the other shareholders should have an opportunity. So they should be well informed if there's been a change of control in the company. So it's not like in the morning they get up and they come to know that there's been a change of control in the public listed company where they're invested. And secondly, also to provide them with an exit opportunity if they feel that it's good for them to exit right now, to provide them with that opportunity. So there is a mandatory requirement that if today you're buying more than 25% of a public listed company, you will have to make a mandatory open offer to the remaining 26% as well. Now, again, in this case, I think somebody last time you were saying, I think there's a lot of question around that L&T and Mindtree and how does that happen and what is a hostile takeover. Again, so hostile takeover is not that you see the other shareholders had no say and you bought 51% out of thin air. In that case, what was the exact thing was that the management of Mindtree at that time was against the takeover by L&T, and they were very against the fact that you should not be buying it. But they, through proper process within the Takeover Code, they initially bought 20% from one shareholder who was willing to sell and who wanted to sell. And after that, through open market, they bought a certain percentage of shares, post which they were in a position to make an open offer for the remaining shares. So once they made that open offer for the remaining shares, there was a lot of, pushback from the management who did not want them to take over control. But obviously, if the shareholders are willing to sell their shares, nobody was forcing them. The shareholders were willing to sell their shares. They sold their shares. It was bought by L&T, and then they took over the company. So that way, obviously, those people who did not sell their shares, who were not willing to share as management, they remained in the company. But otherwise, everybody else who wanted to make an exit and wanted to take that exit, they took that exit. So that's why they termed it as a hostile takeover per se, because obviously the management was against it. Technically, that's not the case, because generally, mostly in 90% or 99% of the cases, everybody is happy to get an exit at a good rate. But in that was one of those instances which were there. But this is under the Takeover Code, which allows you, and the idea is, again, so that you're not stuck in the company. If you're a small shareholder, or if you're somebody who's bought shares in the company, you should not get stuck in the company if there's been a change in control. Change in control and change in ownership means more than 50% or more than 51% of shareholding is changing. That is why the first trigger is there. If there 25% or more, then you have to do it. Another concept for which another mandatory offer is triggered is called a creeping acquisition, which says that if you already own more than 25% shares, and then even if in a particular year you are acquiring more than 5% shares, 5% or more shares, again that will trigger a open offer, compulsory open, mandatory open offer requirement is triggered. Correct. Now, again, the more nitty-gritties of how the Takeover Code works later, within today's session only. Just the idea being, then the other thing is that in the NCLT, there are exemptions. And obviously, if there is a court order which has passed a scheme of amalgamation, then pursuant to that, you are taking over a company, then this open offer requirement is no longer applicable if it's a scheme of amalgamation through which it is happening. So these are the exemptions which are there. So if we move on to the next slide, the listing regulations. Now, when you're doing a merger, in that case, what will happen is that of a listed company, in addition, so obviously for an unlisted company, like we said, you just follow the Companies Act, do everything about what is set out in the Companies Act. That is fine. But in case of an unlisted company, of a listed company, you also have to follow the SEBI regulations. Now, the SEBI has something called the LODR, which we call, which is the SEBI Listing Obligations and Disclosure Requirement Regulations, which sets out that obviously in case of a merger of company, for listed company, in addition to following what all is there under the Companies Act, your NCLT schemes and everything, their NCLT procedure, there's certain other things which you need to do. Firstly, filing of the scheme with the stock exchange. So any listed company undertaking or involved in a scheme of arrangement must file the draft scheme with the relevant stock exchange prior to filing it with the NCLT to seek an observation letter or a no objection letter from the relevant stock exchanges. Obviously, you're a listed company, so you can't unilaterally go ahead and do whatever you want. You will have to, follow this guideline. So you're listed in a stock exchange. A stock exchange is either, say, a Bombay Stock Exchange or the National Stock Exchange, wherever you're listed. You will firstly be required to file that scheme of amalgamation with the relevant stock exchange. Once the stock exchange is fine and it seems that you are not hampering anybody's rights, they say that there's no foul play in what you're trying to do, they can either give you a no objection letter or give you an observation letter in which they set out their observations that these are the 4-5 things which you need to undertake in order for us to be okay with it. But you need a no objection letter from the authority. Compliance with security laws. The listed companies have to make sure that the scheme does not violate, limit, or override any provisions of the applicable security laws or requirements of the stock exchanges. So it should not be something that tomorrow, as pursuant to this merger, there are certain things which happen or there are certain conditions which are there which make it make it unfeasible, which is in violation of the security law. So whatever SEBI has, the laws have, they want to make sure that even after the merger, your company is in compliance with all of those laws. So that is the other thing. Change in shareholding pattern. You are also, as parts of your listed company and you're going for a merger, you have to file with the stock exchange the pre and post arrangement shareholding pattern and the capital structure as per the requirements of the listing authority, so that they know what exactly will be. See, again, what are the security laws? So your security law says that any listed company can have a maximum of only 75% private ownership, 25% has to be public. So it has to be publicly traded shares. So it should not be the case that pursuant to your merger, there is any change in that shareholding pattern. 25% at all times should be fully, freely, publicly traded shares. So for that reason, you have to give a pre and post closing shareholding pattern with the stock exchanges. And obviously the corporate actions, you need to disclose to the stock exchange all information having a bearing on the performance operation of the listed company or any price sensitive information. Again, the idea is that a listed company, there is a lot of emphasis on transparency, because the shareholders of the company, because of the publicly traded company, the shareholders have to have a knowledge about whatever is important which is happening in the company. That is why you see that a lot of times what happens is that the market, the share prices which are happening in the market, there is a fluctuation in those prices because say Tata has made this announcement or this company has made that announcement. And why do they make these announcements knowing very well that it may lead to any fluctuation in their share prices or a reduction of the share prices? Is because they're mandated by law to make a lot of these disclosures which give transparency to the shareholders and the people who are buying or selling the shares, so that they can make a proper and informed decision. So these are the listing regulations which are there. Now, after that, so this is, and again, we'll go in detail in the Takeover Code and everything. We'll go provision by provision. But what is the legal framework in relation to acquisitions? Now, this was mergers, right? Now, acquisitions, if you go to the next slide. So firstly, it's the transferability of shares. Now, transferability of shares is restricted. Either you have to see when you're buying shares of a company, what are the restrictions on that share transfer? Correct. Now, a restriction in the share transfer, you will see that either, or you're buying the shares of a company, you have to figure out what are the restrictions on the transfer of that share or the issuance of that share. Now, that can either be through the Companies Act or it can be contractually. What happens is, as part of the Companies Act, there is a general preemptive right which is there, which shareholders have, that in case you have to issue fresh shares, then all the present shareholders are required to be provided with an equal. So that's a rights issue which you do. They need to be provided with proportionate number of, option to buy the proportionate number of shares. You follow a process, etc., etc., etc. But if I'm buying the shares of the company, there are also restrictions which are contractually agreed to between the parties. Now, those are restrictions also which you need to look out for. General restrictions, which we'll discuss right now to give you an idea, are what you called a ROFO, which is right of first offer, right of first refusal, a tag along right, and a drag along right, just to name a few of these rights which are there. Now, when you have, no, if you can just remain on the previous slide, yeah, thank you. So what's a right of first refusal and what's a right of first offer? The right of first refusal is that for you, so if you have a ROFO today, how will that work is that I will firstly go and go for, if I have a third party buyer. So say that today I want to sell my shares and I have a third party buyer who's come to buy the shares from the company, but you have a ROFO right. So you being one of the other shareholders have a ROFO right on these shares. So I will come to you and say that, listen, I want to sell 100 shares. And there is this very good buyer who's come, who's paying me 100 rupees per share. Can you match this price? Yes or no? I may, because I have this right. So if you can match this price, then I will sell my shares to you. Or if you can't match this price, then I will sell my shares to that person who's offering it, which gives you a good thing, because then it helps you as other shareholders. It gives them an opportunity to make sure that the shares of the company are not sold to some random person, and you have a right to buy those shares if they're being sold out. So if you can match the price, well and good. If you can't, then you can go ahead. The right of first offer will be that I firstly come and offer those shares to you, and I say that without having, so because what is the advantage of a ROFR is that there's a price discovery. There's a price discovery because I already know that 100 rupees per share is being offered on the share, so I can give more or less. Then it's my choice. It makes it easier. ROFO will be that you come to me and say that, listen, I want to sell my shares. I want to sell 100 shares. What price will you offer me? I may say at that time that, listen, I can only offer you 90 rupees per share for this. I say, fine. What I do is then I will, if I can find, either I sell my shares to you at 90 rupees per share, or I refuse to sell it at 90 rupees per share, and I go and find a buyer who is willing to pay me more than that amount. So if you find a buyer who's willing to pay you, say, 95 rupees per share or 100 rupees per share to buy your shares, then you can freely sell your shares to that person. But you can't sell it to another person who's giving you lesser money than me, because then if you want to sell it, then sell it to me at 90 rupees per share. So these are restrictions. So now if you're buying the shares of the company, you need to be sure. Then some people have a tag along right. Now the tag along right generally is a minority protection right, which is given to the other shareholders of the company, saying that, that generally to the minority shareholders of the company, because what happens a lot of times is that the larger shareholders or the bigger players in the, who are there, they are able to get good deals for themselves, and because they have their connections and everything, they're able to get good money and good deals for their shares. And people who own this 1%, 2% shareholding, they're not able to sell their shares properly. So they have a tag along right, which says that if you find a buyer who is ready to buy your shares, you will also, tell that buyer to buy proportionate shares from me or buy all my shares along with your shares. So you find a buyer who's willing to buy your shares plus my shares, because I have a tag along right with you. So that helps in a lot of these small shareholders to get an exit. Now, some shareholders also have this option of a drag along right, which says that if we find a very good buyer who's willing to pay more than an X amount, or say it's been 10 years and we've been in this company and we've not been able to get an exit out of this company, and today we are finding this new buyer who's willing to buy all the shares of the company, we have a right to drag all your shares along with it. Now, why are these restrictions important? Because if tomorrow you are buying the shares of the company and those shares are subject to all of these restrictions, you would first require the seller to get a waiver from the other shareholders for their rights under this. Because then it's a wastage of my time if I'm offering you 100 rupees per share and tomorrow you can come and tell me that no, listen, that those shareholders had a ROFR and now they have the right to pay 100, they are willing to pay 101, so I'm selling it to them. It's a wastage of everybody's time. So you would want them to get a ROFR, you would want them to get waiver for all those rights, etc., etc. So these are all the contractual restrictions which can be there. In addition to what under the Companies Act will only tell you in relation to a primary issuance. In a secondary issuance, all the Companies Act says under Section 56 is that if there is a transfer of shares, the company will record the transfer of shares only if it has a valid instrument, duly stamped and valid instrument of transfer, which is what you call an SH4, the share transfer form. It shall be valid stamped, and you should get that copy. So these are the contractual restrictions which are there for transferability of shares when you're transferring shares. So you go to the next slide. Squeeze out provisions. Again, so the Companies Act has certain provisions which allow the majority shareholders to actually squeeze out the minority. So if you're just 1% or 0.5% in the company and the majority shareholders want to buy you out, so there are few sections which are there. Section 236 says that if you own more than 90% of the shareholding of the company, you are entitled to actually go and make an offer to the remaining shareholders to buy out their shares, the minority shareholders. But at the minimum, what you need to offer them is a valuation, with fair market valuation, which is taken out by a registered valuer, given offer to them in order to buy those shares out. The second thing under Section 230 is that if you're holding more than 75% of the shares, if you hold more than 75% of shares as a shareholder, you have a right to go to the NCLT with a proposal to buy out the minority shareholders at nothing below the FMV. You have to make a business case for yourself. And through the court process, you go about it. And then the NCLT approves your buyout. Then the minority shareholders will be compelled to sell their shares to you. But again, that is also done in very rare circumstances where you have to make a case that you see the minority shareholders are creating a hindrance for the running of the company. It will be better for them and for everybody and for the company as a whole if you buy out the entire company and you are paying them more than what is the valuation of the company, etc., etc. So you have to make a case for yourself when it's there. Then there is a scheme for capital reduction. A scheme for capital reduction again is a similar thing. You have to go to the NCLT to get that scheme passed, where you extinguish the shares. So currently my company has 100 shares, 50 shares are owned by me, 50 shares are owned by 50 other small shareholders. I go for a scheme of capital reduction wherein I say that post this, the company will only have 50 shares which are owned by me, and the 50 shares owned by the other shareholders will be extinguished. But that is also not easy because you will require the approval of all the shareholders for that, and it has to be unanimous, and there are a lot of other restrictions which are there. But again, these are squeeze out provisions which the Companies Act has. Then you have the new issuance of shares. Section 42 and Section 62 of the Companies Act, read with Rule 13 of the Companies Share Capital and Debenture Rules 2014, and Rule 14 of the Companies Prospectus and Allotment Securities Rules, prescribes the requirement for new issuance. Now, a lot of times it's Anjali, just give me 5 minutes. Once we finish the new share issuance, then we'll open the floor for questions before we move on to the next part. Okay. Basically, not all, every time will I go and if I'm to say buy the company, buy the shares of the company, it's not like every time I will, so if I have to take over a company, I would want to buy the shares of the company. Sometimes it's possible that I can go for a primary issuance. Now there are two types of issuances, right, in a company. There is either you have a primary issuance or a secondary transfer. Now, primary issuance is when the company directly issues the shares to the new shareholder, in which case the money is infused into the company. So the price at which if I'm buying 15% or 20% of the shares of the company, then I'm putting money into the company, infusing capital inside the company. And in lieu of that capital, what I'm getting is those 100 shares or those 10% shares, etc. Second is what is called secondary transfer, is when a shareholder sells his or her shares to the other person. So in which case the money is given to the shareholder and not to the company, because the shareholder is selling his or her shares and then I procure their shareholding from them. Correct. Now when we are doing a new issuance of shares, so under the Companies Act, you either have a rights issue where you issue the shares to the existing shareholders. So if the company wants to raise further capital, you issue the shares to the existing shareholders and through a rights issue mechanism. in which case you don't need any valuation requirement or any fair market value report. All you need to do is offer the shares to all the existing shareholders on the same terms. That is fine. But if you have to issue shares to a third party, a new shareholder, new person who's trying to join the company, in which case you have to follow a private placement process, which section 42 sets out, under which the company must engage a registered valuer to arrive at the fair market value of the shares proposed to be issued. The issuance must be authorized by articles of association and approved by a special resolution passed by the shareholders in a general meeting. Now, what is a special resolution? Resolutions also which are passed. So a resolution is something, say if we have a shareholders meeting today and we decide something needs to be done, we'll pass a resolution for it. Because the minutes we've decided that the company will issue fresh shares, then we pass the resolution. Now, passing an ordinary resolution means that that resolution has been passed by a simple majority. So 50.1% or 51% of the shareholders present and voting, they've passed it, and it's an ordinary resolution. Special resolution is that the government says that there are certain matters which require you to take the permission of a minimum of two-thirds of your, so that's a little more than 75% of the shareholders required to pass that resolution, and only then will it be considered a valid thing. So that is 75% or more. So that's what a special resolution is called. In case of issuance through a private placement process, you require a special resolution. Now, why do you require a special resolution? Because if you are issuing shares to somebody new, then it will lead to a dilution in the shareholding of the existing shareholders. Now, imagine today there are two shareholders who own 50% each, right? If two new shareholders are coming in who are buying 25% each shareholding, then as a result of that, your shareholding will also reduce from 50% to 25%. There will be a proportionate decrease. So because it affects your shareholding in the company, the Companies Act says that this is something when you're issuing new shares, the company is issuing new shares, you should have the approval of at least 75% or more shareholders of the company. So that's what the special resolution has come. The explanatory statement to the notice for the general meeting should carry key disclosures. Now, obviously, if you are issuing this and you want the shareholders to pass this particular resolution by a special majority, you should give them all the requisite details in order for them to be able to make an informed decision. Now, how do they make an informed decision? They make an informed decision if you tell them who is the new person who's trying to buy the shares, at what rate is he or she planning to buy the shares, how has that rate been come to. You send them the valuation report. You tell them what is the pre-closing shareholding pattern and post-closing shareholding pattern. You give them the reason why are you doing this. Maybe the company wants money. So because the company needs money for its day-to-day running and you don't have enough money because of that. Or because it's a strategic investor or a financial investor, say it's a Sequoia or it's a SoftBank, which is putting in money in your company because of which you want to issue. So all those details you set out. Now, once this is done and you pass that special resolution and you allow the company to issue shares on a private placement basis, the company is obviously, so what the company has to do is that the company has to give them an offer letter to the new shareholder, the proposed shareholder. That offer letter has to be accepted by them and everything, all this process. But once you have passed a special resolution, the Companies Act says that you have to issue the shares. Firstly, it's valid only for 12 months, that resolution which is there. And the shares, once approved by them and everything is done, have to be allotted within a period of 16 days. So once you get the money for them, those shares, you have to issue those shares within 60 days period to the new shareholder. Otherwise, you will have to pay, you have to refund that money after 15 days thereafter, and an interest of 12% per annum is payable after the 60th day. These requirements apply to equity shares, fully convertible debentures, partly convertible debentures, and other financial instruments convertible into equity. So it's very important that these things are these securities. There's generally equity securities is anything which is convertible into equity. If anything is not, something is not convertible into equity, then it's a debt on the company. It is very clear that the company can only raise money through two means. You can either take a loan or you can take an equity infusion. In case of an equity infusion, you issue these instruments like NCDs, CCDs, convertible debentures, convertible preference shares, equity shares, etc. And if you want to take a loan, then you take a proper loan, or you take an NCD, which is a non-convertible debenture. But you can't, there's no other third way. Thirdly, if you're just taking money from somebody and keeping it with yourself, that's called a deposit. And the Companies Act has proper deposit regulations, and it's a very stringent regime. So you don't want to just take a deposit, because then that deposit means those money that you're just keeping with yourself for someone else, and it's a very tedious process. So that is not what you want to do. So you will obviously follow only two manners: either you take it as a loan or as an equity. Now we can take questions. I saw there was a questions. So if you have any questions in relation to anything, please feel free. What are the contractual? Are these contractual restrictions universal in nature? Are these necessitated for transfer of all shares? No, they're not universal. Like I said, these are contractual. This is what I negotiate for myself. So if I am entering into a transaction with you, I am entering into a shareholders agreement with you, I as a minority shareholder or as a majority shareholder will negotiate these rights with you. So it's all negotiable. It's not set in stone that you have to give me these rights, but obviously as a prudent buyer or a prudent shareholder, if I'm entering into an agreement with you, I will ask my lawyers to make sure that you follow these processes which are there. Right? Because otherwise it leads to a lot of problem for me in the long run. Why do we need these contractual restrictions which are there? Simple. It is in order to maintain your shareholding in the company so that you are not unnecessarily diluted in the company, and to provide you with proper exit mechanism. If you're a minority shareholder in the company, what is your idea? You would want that somewhere down the line you should have liquidity, that you should be able to easily sell your shares. You may think that it is not possible for you to get a proper valuation or a proper buyer after some time. So you think that if the majority shareholder is selling and leaving the company, you can tag along with them. Or ultimately you feel that if after an X amount of time, see, I am putting in money in your company basis an assumption that within the next 5 years I can double my investment, or I can get 1.5x of my investment. But if that is not happening after 5 years, right, and you are not doing anything with this company, you're not making any profits, then I should have a right to drag the company out. In which case I negotiate a drag along right with you, saying that if you can't do anything with the company in the next 5 years and nothing is happening and you've not been able to give me an exit, because what am I? I may be a fund and I'm representing, I'm answerable to my shareholders about what I'm doing with their money, etc., etc. So if you're not being able to give me an exit after a period of 5 years, I should have the right to drag you. So these are contractual rights. There's nothing set in stone. It's not like the law says you have to negotiate these, but it is something typically which everybody does want, and then you contractually negotiate them. So it's purely commercial basis on what you can negotiate and what you can't negotiate.
So we have two questions. One is from Ajit and second is from Shrishti.
Yeah, I'm just so Ajit says that if you can give some light on the recent trend of shareholder activism in India affecting M&A deals. Okay, and Shrishti is, if you can re-explain the difference between ROFR and ROFO. So shareholder activism in India is of late what you're saying a lot, which is happening. The idea is that minority protection rights have increased over the years and shareholders have started becoming active in what is happening in the company. You start seeing that, a lot of times what happens is that shareholders are writing that they're not happy with what the management is doing. The company is not, doing exactly what they had promised in their budgets. The company not doing it. This is shareholder activism has increased over the years. And I think there are a lot of these examples also of companies. I'm not being able to recall them off the bat of my head, but where you can actually see that the shareholders have come ahead and they have started pointing out that the management is not doing the correct manner. Because it's not like if you're a minority shareholder, you're not obligated to just sit back. In India, you have minority shareholder rights, minority shareholder protection rights. So if you feel that you are being, as a minority, you're not shareholder, you're not getting your rights, or you feel that your rights are being suppressed by the majority shareholders, you have rights that you can reach out to the NCLT, you can put a case of oppression and mismanagement against the company, management. You can tell them, you can go to the court and say that this management, the way they're running the company, that they're actually, it will lead the company to nowhere. and so all these things are there. Or you think that because there are some other vested interests in mind because of which they're doing something with the company, you could freely go ahead and actually do a lot of things. And shareholders do have a lot of rights. Minority shareholders have rights under which they can do. There are a lot of things. Obviously, even for a case of oppression and mismanagement, it's not like a 1% shareholder can go ahead and file a case of oppression and mismanagement. You need at least 10% cumulatively shareholders representing 10% of more of the equity to go and file that case. But yes, and that shareholder activism of late has increased a lot. If you ask, explain the difference between ROFR and ROFO. See, in one case, what happens is that I come to you first and tell you that I want to sell my shares, right? And I'll tell you that I want to sell. So basically, who are these rights inter se amongst? These rights are generally inter se amongst the shareholders of a company. So imagine a scenario where Ajit is a shareholder and say Suresh is a shareholder and Ashwarya is a shareholder in a company, and I am a shareholder. 4 of us are shareholders in a company. So now these other 3 people who are there, these 3 people have a ROFO right or a ROFR right, depending on what it is. Now, the first type of right is that I have a right to first offer. I have to first offer it to them. In which case, I will go to them and I will say, see, Ajit, Suresh, and Ashwarya, I am planning to sell 100 shares of the company. Are you people willing to buy proportionate to your shareholding? And if yes, what is the rate you're planning to sell to me? They will say that, okay, fine, we are interested in buying your 100 shares and we will pay you 90 rupees per share. Correct? Now, I know the price which they are willing to offer me, 90 rupees per share. If I want to sell it to them at that rate, fair and good. If I don't want to sell it at that rate, I will say that no, I will go and look for a buyer who's paying me better money. I go, and if I am able to find a buyer who's willing to pay me 95 or 100 rupees, then I am free to sell my shares to that person, because I offered it to you. You offered me a low valuation. This person is giving me more money. So obviously commercial prudence says that I can sell it to him. I'm free. But you had the right, so I firstly came to you. Then the other idea is in which what I do is that I get an offer from a third party. So say some Nikhil who's there. So if Nikhil has given me an offer that Siddharth, I will buy your 100 shares for 100 rupees each. I have that offer with me. Now, because you people have this contractual right under the contract, I first have to come to these 3 and tell them that, see, this guy Nikhil is there. He's a buyer. He's given me an offer to buy my shares at 100 rupees per share, and I'm inclined to sell. Can you match or better the offer? In which case, if you are able to match the offer and pay me 100 rupees, or you say, no, we'll pay you 105 rupees. In that case, I would go and sell it to you. I would go and I will actually, sell my shares to the existing shareholders, or I would sell my to them because they had the right and they've been able to match the right. So it's the difference. The only difference between the two is price discovery. In the first instance, when I come to you, I don't know the price and you give me the price and I have to buy in a better price than that. In the second instance, I already have a price in the market. I come to you and you either match it or give me a better price for that. So does that explain the difference?
Yes, sir. Thank you.
Cite a few instances where there are any contractual rights fall afoul of the laws. These contractual rights are again, these are contractuals. They won't fall afoul of the laws. Obviously, in any case, you cannot contractually agree to something which is against the law. But under the Companies Act and especially for private companies, there are a lot of exemptions where you can contractually agree to things, even if they're contrary to what the certain sections for which an exemption is given, there is a notification by the Companies Act. But if you say that if the ROFR or the tag or the drag, they are, fall afoul of the laws, there's no such instance. The only thing I can think of is that if they fall afoul of the foreign exchange regulations, what happens is that contractually under the FDI policy, you cannot promise any foreign investor, an assured exit or an assured return. So you cannot tell any foreign investor who's investing in an Indian company that 5 years down the line, I will 100% sell your shares for twice the money. And if I cannot sell it to anybody for twice the money, I will buy it out. I'll put the put option that I will buy your shares at 2x the amount. So you put it right now. So you can't give anybody an assured exit, foreign investor an assured exit as part of any optionality clause. So that is where the law will fall afoul. But other than the fact that it's not in compliance with the foreign exchange regulations, within the Companies Act, it's not generally anything where you will actually fall afoul, unless and until you're being too creative about it. The news of merger comes out officially, but before that, the news comes out, a few big bulls buy those shares as if they had information about merger. How does SEBI deal with this? That's a good question, and we'll be dealing with this in this session as well. I think when we go ahead, we'll have a thing on what are the SEBI disclosure requirements and what is the SEBI regime when it comes to UPSI, which is your price sensitive information. Right. So there is certain people. So we have a lot of insider trading regulations, which the SEBI has to deal with this. And we'll deal with this right now in this session only when we go ahead, that SEBI has insider trading regulations, which make sure that anybody who has any price sensitive information is not allowed to divulge it to anybody. There are things when you are working in deals, we have Chinese walls. The deal is generally supposed to be restricted only to a few key members, etc., etc. We'll discuss all of this in detail as we progress right now over the next 1 hour. But yes, there are things which are in place. If you are doing it and you still leak the information, then it's obviously you're breaking the law. And Ajit, your question on blank check companies also, when we are discussing SEBI regulations after this, we'll discuss in more detail. So over there, I think it will be better once I'll discuss it once I'm explaining the laws as well. So it'll be, much easier for you. Now, again, issuance of shares with differential voting rights, correct? Now, the Companies Act says that you can issue shares with differential voting right as well. So if I'm buying a share, now why is this important when you are as part of an SPA transaction is to see if your shares that your client is buying, are they shares with differential voting rights or are they shares which have equal voting right as someone else? Now, what does that mean? Now, in generally, one share will get you one vote. Right, one shareholder, one vote, or whatever your voting percentage is commensurate to the number of shares or the percentage of shares that you have. Right. So that's how it works. If there are 100 shares, 100 shareholders, everybody has one share, so everybody has 1% voting right. But the Companies Act allows you to actually go ahead and issue differential shares with differential voting rights. Differential voting rights would mean that I would say that you are getting shares, but they don't have any voting right. Or maybe 10 shares of this category that I issue to you, those 10 shares cumulatively will give you one right, just a right equivalent to one equity share, which the other people have. So this you generally do. So say if I want to issue shares to one of my employees, but I don't want to give them, or someone else, but I don't want to give them voting rights, I'll issue them shares with differential voting rights. The Companies Act allows that. What it says is that there's certain things with a different differential voting right. You can limit the voting, the dividend right, in that share as well. So you can say that while all the other class of shares, the normal class of equity shares will get their entire dividend, this particular type of shares which I'm issuing, the class of shares which I'm issuing, you will not get more than, say, imagine 5 rupees or 10 rupees of dividend on those shares. So I can restrict it like that. What you need to do is that you need to pass an ordinary resolution. Your articles of association should allow you to do that. Differential shares with differential voting right can at no time exceed more than 74% of the total voting power of the company. And for any company to be able to issue shares with differential voting rights, you have to be sure that the company has not defaulted in its filing statements and annual returns for 3 financial years immediately preceding the financial year in which it has decided to issue these shares with differential voting rights. Private companies are exempt from these requirements if their memorandum and articles of association so provide. So if your articles of association specifically set out that you can issue differential voting rights without following sections in the Companies Act, then in that case, private companies have an exemption to go ahead and do it without following this procedure, which is set out. The next slide, please. Limits on an acquirer. Now, from an acquirer perspective, when you're looking at the Companies Act, you need to make sure whether or not your client, being an acquirer, is permitted to sell these, to buy these shares or not. Now, there's no restriction per se. There is a free thing that you can actually do it just by a board resolution, or you require a special resolution which your shareholders have to pass. So section 186 of the Companies Act says that if, it puts certain limit on intercorporate loans and investments. So if as an acquirer, I am buying a company for which I'm paying more than 60% of my paid up share capital and free reserves, or more than 100% of my free reserves. In that case, I have to, going beyond these thresholds or monetary limits, I will require the authorization of the shareholders by a special resolution. So again, because you are investing so much money of the company and you are actually going beyond 100% of your turnover to buy another company, or more than 60% of your paid up capital you're using to buy that company, you will have to take a special resolution from more than 75% of the shareholders. More than 2/3 of the shareholders have to agree to it. And that is only in that case, more than 3/4 of your shareholders have to agree to it. And it is only then that you can actually go ahead and buy that company. So that's a limit which you need to see on whether or not, as from a corporate compliance perspective, your client is required to adhere to these guidelines or not. Get a special resolution, or can it just buy it with a board resolution? If you go to the next slide, an asset or business purchase. Now, from a seller's perspective, it becomes very important that when the Companies Act says that if you are selling or leasing of whole or substantially whole of any undertaking of the company, you require the approval of the shareholders by a special resolution. Again, the idea is that your Companies Act defines an undertaking to mean any part of your business which contributes more than 20% of your total income. So if you're selling any part of your assets or any part of your business which contributes more than 20% to the total income of the company, the Companies Act will mandate you to go ahead and take a special resolution for it while selling, and you can't just go ahead and sell it just basis of a board resolution. Again, because if it's something as substantial which is contributing more than 20% of the income of the company, the majority shareholders, and that is a good 3/4 majority of the shareholders, should have a say in whether or not that asset should be sold or not. So then again, there is a limit on the Companies Act, which the Companies Act puts on you to buy those shares only to buy those assets of the company, only post a special resolution. Now the SEBI ICDR regulation. Now what happens is when you're issuing the shares of a company, or you're transferring the shares of a listed company, you also have to follow the SEBI Issues of Capital and Disclosure Requirement Regulations 2018, which are generally called the ICDR regulations. Now, what additional restrictions they put is that there is a separate mechanism for pricing in case of the ICDR regulations. The ICDR regulation says that when you're doing a preferential allotment of the shares, a new issuance of a shares to a new shareholder who's coming in of a listed company, you have to make sure that those shares, the price of them is the two ways is calculated. If the company has been listed for more than 26 weeks, then the average price of that share on the stock market for the last 2 weeks is what you take into the account. Or if it's a company which has been listed for less than 26 weeks, you take the price at which the equity shares were issued via initial public offer, or the price per share which arrived at under the scheme pursuant to which the shares of the issuer were listed. So this is a pricing which is different. The other restriction which the Companies Act, which the ICDR regulations put on you, is that if you acquired the shares, if you're a new acquirer of the shares through a private allotment or a preferential allotment basis, then what you would need to do is that you locked in for a period of 1 year. What does lock-in mean? Lock-in will mean that after I bought the shares for preferential allotment of a listed company, I cannot sell those shares for a period of 1 year or do anything for them for a period of 1 year from the time that I bought those shares. from the company. Now, just give me a second. I'll just have water. Now we'll discuss the Takeover Code. Now, like I said previously, the key objective of the Takeover Code is to provide the shareholders of a listed company with adequate information about an impending change in control of the company or substantial acquisition by an acquirer, and provide them with an exit option in case they do not wish to retain their shareholding in the company. Just one second. So that is how you go about it, and that's why the Takeover Code comes into place. Again, the idea is shareholder protection. You have to protect your shareholders and give them a right that tell them that, okay, you had invested in this company when A or someone else was, say Mr. Ambani was the owner of the company, and now because Mr. Adani is taking over the company, you have a right to either sell off your shares of the company or be properly informed about it as part of that public offer process. So if you can proceed to the next slide. Again, now I'll just repeat it. Very important is to make sure that in case of an acquisition of a publicly listed company, there is a takeover code which requires you to say that initial trigger is that if you are buying more than 25% of the shares of that company, you're not a shareholder of the company, or you hold less than 20% of the share of the company. But pursuant to this transaction, you will own 25% or more of the shares of the company. So it's possible that you own 24% of the shares of the company and you're acquiring 2% shares. But because that 2% shares results in you exercising more than 25% of the shares of the company, you are mandatorily required to do an open offer. And the open offer has to be of a minimum of 26% of the shares of the other shareholders. So you can't just buy 25%, you have to give an option to the other shareholders to buy their 26% as well, so that basically the 26% figure comes, so that cumulatively 25 plus 26 results in 51%, you taking over the company. So as per the Takeover Code, you have to make a mandatory offer to them, a public offer to all the other shareholders, in case this first trigger is met. And that first trigger is you exercising 25% or more of the voting rights in the target company, as part of the transaction that you're undertaking. So that's the initial trigger. Then there is a creeping acquisition, like I said. So if you already own more than 25% of the company, or 25, 26%, whatever percent, and between 25 to 75% of the company, you have the option. And if then you're buying 5% or more also, you have to compulsorily do a offer, a mandatory offer, because then what this is called is a creeping acquisition. It cannot be the case that you keep on buying 5% and taking over the company eventually without anybody else knowing. So again, the idea is that if, because you already 25% or more and now you're buying more than 5% in a particular year, you will have to go and give a mandatory offer to buy out the shares of the company. So that is the other trigger which is there in case of a creeping acquisition. Now, the third thing which the Takeover Code also says is acquisition of control. It's possible that what you are acquiring is less than 25%. It's possible that you are only acquiring 20% of the shares. But pursuant to that 20%, what you're getting is that you have some contractual right to exercise control over all the other shares as well of the company. So what it says is that if you're acquiring control over the company, then you have to do that through the Takeover Code. And obviously, what constitutes control is most often subjective test and is determined on a case-to-case basis. What all rights are being given to you as part of it, what all are the other factors which are there, all of that needs to be taken into consideration in order to figure out whether or not a control is taking place or not. And then the SEBI can ask you to mandatorily do an open offer, because you can't do indirectly what you can't do directly. That's a simple fund of law. The other thing which we're now doing is a voluntary open offer. What is a voluntary open offer? Now imagine one thing is that you have a mandatory offer. So the law says that if you are breaching the creeping acquisition trigger or the initial trigger, you are mandated by law to give a public offer to all the remaining shareholders of the company. But if say you are already holding 25% and between 25 to 75% of the shares, you don't want to you don't need to wait for a mandatory trigger, and you can of your own accord go ahead and make a voluntary open offer of all the remaining shares of the company up to 75%. Because like I said, under the security law, 25% of the shares of the company have to be freely traded. You can't own the entire 100%. Then it's a closely held company. Minimum 25% of the shares of the company have to be freely traded over the stock exchange. So then you have an option to actually go ahead and make a voluntary open offer. A voluntary open offer has to be for a minimum of 10%. So if you're making a voluntary open offer in the market, it has to be a minimum of 10%, which is there. As per SEBI's Takeover Code, you have FAQs, so the frequently asked questions. Any person holding less than 25% of the shares can also make a voluntary open offer. But in this case, it has to be of a minimum of 26% to begin with. And any person who's been declared as a willful defaulter or as a fugitive economic offender cannot make an open offer or enter into any transaction that would attract obligations to make a public announcement of open offer, which is fair enough. But the other thing is that before we proceed, that even if you make a mandatory open offer for the remaining 26%, the Act allows someone to make a competing offer with you. So if say today I am buying pursuant to this transaction, I'll be buying more than 25%. So I make this mandatory open offer to buy the remaining 26% as well. So someone else has the right to make another open offer, a counter offer, in which you will have to say that I am also willing to buy that initial 25% which he's planning to buy, and in addition to this 26% also I'm making a better offer for everybody. The idea ultimately is that if somebody is out there in the market who's willing to give a better offer for the company, and because it's a publicly listed company, that person should also get a right to make his or her offer. So you can make a counter offer in that case. Then these are the listing obligations which are there. And I would envisage, I think, only one question so this is where the listing obligation and disclosure requirements came, and somebody had asked about the disclosure requirements and the insider trade regulations. We're coming to that part. Now, the listing regulations obviously give a comprehensive framework of the governing various types of listed securities. The important thing which you need to make sure as part of the merger and acquisition regime under the listing regulations is that there is a regulation 30 of the listing regulations, which says that you puts an obligation on the companies to make a disclosure of any material event which is there. As a result of this, a lot of publicly listed companies, what they have is they have a disclosure policy which is there, which sets out the threshold, which decides what is material and what is not material, and in that materiality which is there. The idea again is specifically that all of these transactions, there should be a lot of transparency which is taking place. So if today as a company I have signed a term sheet which says that we are entering into a new transaction which is non-binding, then I'm not obligated to make that. Some companies have a materiality policy which says that even that is material enough for them to disclose. But say my company says that if I'm signing documents today, definitive documents that I'm selling off the company or I'm buying a huge company, then I'm mandated by law to make that disclosure over there. And these are the type of disclosures, and once the documents are signed that this company is being taken over by another company, etc., that these are the type of disclosures which affect your share prices and everything. That's what you come to know, this news that the stock exchange disclosure has been made by this company or that company, and because of that there's been a lot of fluctuation in the share prices of that company. That is why these companies are obligated under law to make these disclosures. So there has to be a lot of transparency when it comes to these disclosure requirements which are there. Now the listing regulation divides the events that need to be disclosed into two parts, right? Firstly, events that have to be necessarily disclosed without applying any test of materiality, which are indicated in paragraph A of Schedule 3 of the listing regulations. So those regulations, if you see para A, it says there are certain types of transactions, like again if I'm selling an undertaking or if I'm doing something of that sort, which without applying any mind of, even if it's that undertaking, whatever the amount it is, then I have to make a disclosure, public disclosure about it. If I'm issuing new shares, if I'm doing any of these things, there's a mandatory disclosure. And para B indicates events that would be disclosed by the listed entity if considered material, for which every company has a separate materiality policy, which is publicly available. So what you will see is for all the publicly listed company, all of their information is publicly available. Go to their websites, they're very well maintained because they have to provide all that information to the shareholders and the prospective shareholders so that everybody can make a properly informed decision. These are disclosure requirements. Now we come to that question which you were asking about, what is the prohibition of insider trading? Right? Now, insider trading, why do we do that? Like you very nicely said, that if this information is leaked about something, now imagine I am planning to buy this company, and after this company is bought, once the public announcement is made that I'm buying this company, my revenues will double. And because of that, my share prices can hit through the roof. Now, if anybody gets to know this information beforehand, then you can actually buy the shares of that company and use that thing to manipulate your own profits, right? Or if I have information that this company is planning to sell off its entire shareholding into different buyers, and they're planning to shut shop, I have what is called unpublished price sensitive information, because this is the information which the management is discussing. Now, if I tell this to someone and I tell them, listen, right now the price per share is 100 rupees, but after this announcement, it will become 50 rupees to sell off your shares overnight, then anybody can manipulate the market that way. So what is there is that the government has these insider trading regulations in place. And it prohibits any insider from communicating any unpublished price-sensitive information. Any person who procures the UPSI from an insider and an insider from trading in securities when in possession of UPSI. So even as lawyers, what is important is that as lawyers, you will be conducting, say, a due diligence of a listed company. We, especially in Khaitan, we have special clauses that we tell, our clients that we are, that we are a company which follows very strict insider trading protocols. And in fact, as Khaitan, we are required. So I am personally required every quarter to give a list of all the shares that I'm holding, share securities that I'm holding. And whenever there's any change in those shares, I have to inform Khaitan that, okay, so these are the shares I was holding. So this is the change in my shareholding pattern. And they will also make sure that they do not staff me on a matter of a listed company of whose shares I have. So, those type of counterbalances are there. And so they keep it. And if I am working on a matter, say if I'm working on a matter for Tata, and I know a lot of information, because when you're doing a due diligence, you look at all the papers of the company, you look at all their confidential documents, you do everything. So that is UPSI, unpublished price sensitive information. So I am forbidden by law to share that information with anyone else, or to trade in those securities, or me, my immediate family, someone in my close relation. I am forbidden by law to do it if I have UPSI with me. Go to the next slide. Now, what is an insider? The regulation, insider trading regulations say that an insider is a person who is a connected person or a person in possession or access to UPSI. Now, the second part is broad enough, which says that any person who has possession or access of UPSI can actually go ahead and it becomes an insider trading. So then those apply to you. But who is a connected person? A connected person is any connected person who is directly or indirectly associated with the company by reason of frequent communication with its officers, by being in contractual, fiduciary, or employment relationship, by holding any position, including a professional business relationship with the company, whether temporary or permanent, that allows such person directly or indirectly to access the UPSI, or is reasonably expected to allow such access. So again, it's a very broad idea. So the idea in this is that anybody who's working in the company, any officer of the company, any employee of the company, or if they have gotten financial advisors or legal advisors on board to do any transaction, we are all people who have this UPSI. We have unpublished price sensitive information. And again, what is price sensitive information? Unpublished price sensitive information is any information which, if released to the public, can have an effect on the pricing of the shares. Right? as it may be something, as important, like say if I have a CEO of the company and I know internally that maybe there is a sexual harassment complaint which is about to be filed against that person, and there is some dispute which is going on internally. So it's internally that management discussion is taking place. Now, if I go and release that in the market, then obviously it will have some repercussion on the price of the shares, because then that person will have to quit. Then he was a very renowned CEO, because of which, he was driving the sales of the company. If he has to quit because of any fraud allegation which is coming in his way, or any other thing which is coming internally being decided, any decision to say sack that person because there is a complaint against that person, there is a decision being taken at management level to sack that person. Now, that through the market that will send a wrong signal or a right signal, whatever it is. So that's unpublished UPSI. So all this kind of information, if you're in possession of, you cannot disclose them. So you are forbidden by law to do that. So we go to the next slide. So again, that any information, again, the definition I've told you relating to a company, securities directly or indirectly, that is not generally available, and which upon becoming public is likely to materially affect the price of the securities. Financial results, dividends, change in capital structure, mergers, demergers, acquisitions, delistings, disposal, expansion of business, and such as a transaction and changes in key managerial person, the KMP. Generally available information is that accessible to public on a non-discriminatory basis. Generally available is what is available to everybody. I can Google it, you can Google it, anybody can Google it, and that's generally available information, non-discriminatory. But if you have special access to any information, that's UPSI. Right. So that is how those disclosure requirements work. When we as a lawyer are doing a due diligence exercise, and we are carrying out a due diligence exercise, we are a listed company, we have to follow these UPSI protocols. In fact, what we have to do is that your law mandates us to maintain a clean team. A clean team will be that, a certain set of only 5 people who are allowed access to that information. And we are not supposed to share it with anybody else. We are supposed to maintain Chinese walls with our other colleagues who are working on the matter. So there is a list of protocols which you need to follow to make sure that, because if I am a listed company and I am sharing my information with you, and you are a lawyer and who's conducting a due diligence on me, I would want that you are following all these protocols in place, because otherwise it's very sensitive information. If tomorrow you end up leaking it, what will I do? Because say a lot of part of my diligence process, I am giving you my future projections, or I am giving you my client list, etc., etc. It's too much confidential information at play, in which case I can't afford you to leak it. So you have to follow it. So that's what the law mandates. Obviously, how companies do it is still they do not share everything when it comes to listed companies upfront. And how they try and do it is that they do it in phases. In the first phase, when they think that the company is, still not, we're not sure about that, whether or not we're going ahead with the deal, and we don't have anything, concrete which has been signed, they will make you give you redacted documents. So they will not tell you the names of the biggest customers. They will just say customer 1, 2, 3, 4, 5, redact their names and share redacted files of those documents with you. So things like that they do to maintain confidentiality. Now, before we proceed with the further parts, I think there are a bunch of questions which need to be answered. Starting with, I think Ajit has 2-3 questions, I think. So Ajit's question is that, would you please explain about blank check companies in relation to SEBI regulation laws in India and future project? So I think this blank check regulation, you've picked up the term from all these PAC transactions which are taking place, right? The special purpose acquisitions or something. Blank check basically company is which has no plan in itself. You form a company and you raise capital for that, and then you say that we want to buy another company to do an M&A. This is happening a lot in the US. You are hearing a lot of Indian companies like Renew and all, like Khaitan worked for Renew. So what they are going is they're going the SPAC route, which basically says that you set up a company, it's a shell company, and that major idea of that company, say the philosophy of the company is that I want to acquire, say, anything in the food and beverages section, and I want to expand in that area. You list yourself through the SPAC proceedings in the US market. Once you're listed over there, you raise money in that market. You use that money as a blank check company to go ahead and buy companies in India. And once that company happens, that purchase happens, that company is merged with the original company, and then you're indirectly listing in the US market. So that's a way which a lot of people are doing to indirectly list, because if you're buying a company out, so that's an indirect listing of that company in the US markets, and the blank check company raises money in the US and other foreign jurisdictions to buy that company. In India, currently, the listing regulations don't allow a company which doesn't do anything to go ahead and list itself. So blank check company cannot go and list itself under SEBI regulations, but we are evolving. If you would see latest guidelines have come up, your IIFC or your International Gift City, which is there in Gujarat. For Gift City, they've been allowed special listing regulations came for the companies which are set up in Gift City, and they're planning to set up their own stock exchange. So over there, blank check companies or your see special acquisition vehicles, these PAC companies, special purpose acquisition companies, they are being allowed to be set up over there. So there is a future, because it's a very hot thing which is happening. A lot of people are rushing towards it in the US. A lot of our clients want to understand how they go the SPAC route through the US, for acquiring other companies, for raising capital, and then doing an indirect listing in the US over there. But yeah, that's the SPAC regime. It's still in the nascent stage in India. But when you hear about Indian companies doing it, they're doing it in the US, listing in the US. You would have not come across anything happening in India with that. But again, the laws are being made, and it's the process. The Gift City has started it. Everybody else will, follow, especially SEBI as well. Your second question, which is here, is please explain about NDA, its importance, clauses, and if possible with ITR. ITR is, what do you want by ITR? No, NDAs, I know, non-disclosure agreement. What do you mean ITR, if possible with ITR?
Ajit, if you could probably unmute.
Insider trading, what you're saying. See, non-disclosure agreements. Now, anytime when I am also, as a lawyer, doing any diligence on a client, or you as an acquirer want to buy the company, and you want that, that I am planning to buy this company, we have entered into a term sheet. Now, because I want to buy your company, I want to do a due diligence on your company. As part of the due diligence, you will be sharing some confidential information with me about your company, right? So now, if you are a seller, you won't just randomly give me that information. Now that, there's a lot of good faith in what you're doing. Come, take all the documents and do whatever you want with them. The non-disclosure agreement will set out that you are planning to enter into this transaction. Now you're planning to enter into this transaction, pursuant to which what you're doing is that you will be getting access to a lot of confidential information. It obligates you not to disclose that confidential information to any person other than the people who are your advisors, and to discuss with them, and to use that confidential information only and only for the purpose of coming into a decision whether or not to go ahead with that transaction. So you put generally those restrictions on the person to say that you will not be using those confidential information for your own profitable purpose. You will not be passing it on to anyone else, etc., etc. The only time you will be using that confidential information is that if you're actually going ahead with this transaction, and that to help you make the decision on whether or not to go ahead with that transaction. But other than that, no, you will not be doing it. We put confidentiality obligations on you, and obviously a breach of an NDA. If you're going and if you're breaching the NDA using my confidential information and starting an own product of the same line, have a discussion with me, look at my papers, see these 5 new products that I'm launching in the next few months, and go and start those same 5 products, I will sue you. I will sue you for damages under the non-disclosure agreement. NDA is very simple. Your non-disclosure agreement, as it says, you're not required to disclose my confidential information to any third party, or even use it for your own purposes other than for this transaction that we're entering into. And with the insider trading part is, again, there's the insider trading regulations. So you say that it's what I am sharing with you, we're a listed company. What I am sharing with you is a UPSI. It's going to be unpublished price sensitive information. So you have to make sure that your associates and your advisors and everybody you are dealing with is, adhering to all the insider trading regulations which are there. is actually signed on to it, they are also signed equal NDAs with you. So my NDA is obviously with the person who's buying the company, but that person should have equal NDAs, back-to-back NDAs with all of its advisors, because ultimately I will sue you. You are the buyer, so the breach has happened at your end. I had given this information because you wanted to buy my company. So if there's any breach, I will come after you. But obviously, I will prefer that everybody you are engaging is also signed proper legal documents saying that they will not disclose this information to someone else. Does that answer your question, Ajit? Yeah. Good. I think that's all the questions that were there. Any other question before we proceed?
Sir, I have a question.
Sure, Shabazz.
So, when we say we are doing due diligence, so I did due diligence of a property. So when due diligence of M&A happens, do we submit it in a form of reports with supporting documents,
Correct,
or
correct. So that's what they pay you for, na? We are being paid to submit reports as a lawyer. So ultimately, you've done a very good job. You've done everything. How do you report? So, and tomorrow, in part of basically tomorrow's session, we will see how we make a due diligence report. So tomorrow's session is about what are the sections of a due diligence. So there is a corporate part of a due diligence. Then there is a labor laws you have to look at. Then there, from a tax perspective, you have to look at things. You have to look from a contractual perspective, what all contracts are there, etc., etc. So what are the different angles or different chapters of a financial finance chapter? How do you do from a legal perspective? So what are the different chapters of a due diligence report which are there, and from a legal perspective, and what all to look for, the general things in each and every chapter, what all laws to look for, what all. So there's a regulatory compliance regime which you have to look at, and one chapter says what all permits and licenses the company has, etc., etc. So tomorrow's session is first session is all about due diligence and the laws you have to look at when it comes to a due diligence exercise. Right. But yeah, so ultimately what happens is that once you do a due diligence and we've done a proper due diligence exercise, we are required to provide the client with a due diligence report. That report will set out what are your red flags, a red flag only. So, and there are different types of due diligences also, and we'll discuss them in detail. So basically there is a red flag due diligence report, or there is a full-blown due diligence report in which I'm summarizing each and every document that I've seen, and I'm reporting each and every document. But nowadays what happens is that these clients, they're all very busy. We are dealing with the board of directors of the company, so they don't have time to go through a 500-page report that you've made. What they will ask you is to present a 20-25 page key issues list to them, saying that, okay, we've done a due diligence on the company. These are the key issues which you need to look at to decide whether or not you want to buy this company, or how do you want to manage your risk in relation to that company. So that's how it's done in due diligence process. But yeah, ultimately, your long story short, you need a report. I mean, because something the client also needs, and more than anything, you need it for your accounting purposes. You need it for your own records that, okay, we did not buy the company because of this, or we bought the company knowing these things because we figured out that the risk was not that much. That's why you need it. So is there any other question, or shall we proceed now? I think we can proceed. So the Competition Act, like we said, that when any merger or acquisition is taking place, you also need to take into consideration whether that particular merger or acquisition is notifiable under the competition law. Now, the Competition Act will basically say that, again, why do we have the Competition Act? The Competition Act is if two huge multinationals or two huge conglomerates, they are combining each other. The Competition Act would want to make sure that their combination is not detrimental to the competition in the company, or somehow it should not be the case that whenever those two entities are merging together, it should lead to a scenario where they have so much money and so much power is concentrated amongst them that the small players have no say at all. Because if both of them are, say, one company has 50% market share, the other one has 46% market share, and if both of them are combining, then after that, they can easily eat up all the competition and will not leave anything for anybody to enter that market. So the Competition Commission of India has to be sure when these mergers are taking place, we have a proper regime in which you actually make sure that what is your market share, what is not your market share, and basis that whether use this new entity which will come into picture, Is that should that be allowed or not? So that there's no abuse of a dominant position by those companies, and they're against any anti-competitive agreements that come into place. Now, again, with the idea of an ease of doing business perspective, there is a small company exemption, which under mostly of your startups and everything fall under that small company exemption. So you obviously don't need to go ahead and see what is the market share and what is, what all are they selling, what is the dominant position or not. So as long as the company has the assets are valued less than 350 crores and the turnover of that company is not more than 1,000 crores, you are fine. You don't need to look at anything else, and you can go ahead with the transaction without taking a CCI approval. CCI is the Competition Commission of India. So you don't need to do that as long as you're meeting the small company exemption. Obviously, if you are going beyond the small company exemption, then you have to look at the fact on whether or not the company is in a dominant position, whether or not post the merger the companies will be in a dominant position, and what all is there. But yeah, so that's a limited thing which you need to look out from a competition perspective. Now, FDI, foreign direct investment into India. Like I previously said, that when you become a corporate lawyer and you're going to be dealing with a lot of foreign clients, mostly you would see that, what we are looking for in all of this Make in India and through the ease of doing business and everything is to invite foreign companies to come to India, make in India, invest in India. So now how does that happen? All of that is directed through, or all that is governed by the FDI regime in the country. So your Indian Exchange Control Regulations, which are your FDI regime in the country. Now that is what basically controls everything. Now, like I previously said, that as part of the FDI regime, you have two things which you need to look at. You have the Foreign Exchange Management Non-Debt Instrument Rules 2019, and you have the Consolidated Foreign Direct Policy, which has been issued by the DPIIT. You have to look at these and figure out whether or not your particular client, in which industry he or she or that foreign company is investing, is it permitted to make foreign investment in that company? And if it is permitted under foreign policy or in the FDI policy, what are the restrictions and modalities over there? Non-debt instruments have been defined as all instruments and equity instruments of an incorporated entity, all instruments of investments recognized by FDI policy, any mutual funds, any units of a mutual fund, junior-most layer of a securitization structure, acquisition by sale of dealing directly in movable property, contribution of trust, etc., etc. There's this laundry list of items which is there. So you can proceed to the next slide. Prohibited sectors. Now, there's certain sectors under the FDI policy in which you cannot, come what may, invest in any company. So you can, being few are in one of these sectors, you are not allowed to get foreign investment. So if it's in the lottery business, if you are in a company which is doing gambling or betting in casinos, chit funds, a nidhi company, you are trading in transferable development rights and real estate business if your company is in, if you're manufacturing cigars or tobacco, or sectors not open to private sectors such as atomic energy, railway, etc. So there are a lot of restrictions when it comes to these sectors and you're getting foreign investment. Real estate business, why they do it is that because the idea is that they don't want that if a company is purely in real estate business, and real estate business is just a business of buying and selling of land. If I am making a construction company and I'm constructing something in a township or something, I can still get foreign investment. But if you're in a real estate business, which is purely just buying and selling of land, you cannot get foreign investment over there. You cannot be in a lottery business and do it. Again, these are very technical areas where the government does not want foreign interference. You do not want that, somebody, if foreign companies are running gambling companies in India, or they're, running a lottery business in India, which in itself is restricted in a lot of states, and a lot of states have a lot of restrictions when it comes to that business itself, even for Indian companies. So obviously that's a big no-no for foreigners to come in place. And obviously things like atomic energy, railway, etc., which are of national importance, your government has a lot of restrictions for those as well. Although now there is talk that there should be privatization of railways, etc., etc., but even in that case, they will not be allowing foreign investment anytime soon. Then there are things in the FEMA where they say that there is no restriction at all. So there are lists of companies which have 100% automatic investment, where you can actually go and you can, under the automatic route, put as much money as you want to in that company and even own 100% of that company. Foreigners can own 100% of the company. No restriction whatsoever. Mostly nowadays, if you open the FDI policy, what you would notice is that most of the companies nowadays are 100% FDI under automatic route itself. They don't have these restrictions of limits which are there. The FDI policy obviously does not list out each and every sector in the world. So what it has is a catch-all clause which says that anything which is not listed as prohibited or anything which does not have any specific conditionalities which are listed out in the FDI policy, all those sectors have 100% automatic FDI. So if there was any sector which we wanted to regulate, where we wanted there to be certain conditions, we've set it out in the FDI policy. But if you're doing any business which is not set out over here, that means it's 100% allowed. You can have 100% foreign investment in that company. Your IT companies, ITES companies, all of these other technology companies, they all fall under this catch-all clause, and then they get foreign investment. Automatic route versus government route. Automatic route means where money can come into the company, foreign investment, without government approval. And government route means that money can only come into this company by taking either an RBI approval or an approval from any company which is there, any government department which looks after it. Like I said, that if today you're getting foreign investment from a company which has Chinese investment in it, you would require the clearance from the Ministry of Home Affairs, which has to give a security clearance for that transaction, without which you cannot invest or go ahead with it. So whenever you read the 100% automatic route or a government route, automatic route means you can easily put in money without any government interference, and government route means that you need government approval, which can be from a government department which is there, or the RBI going forward. Indirect investment. Now, like I said, the golden rule of law in the country is you can't do indirectly what you can't do directly. Now, the law says that foreign direct investment is when a foreign company is putting money into India, right? Now, what if you have a company? So what you do is that you open an Indian company and you open a wholly owned subsidiary in India, the foreign company. Now, that technically that wholly owned subsidiary is an Indian company, and if tomorrow that company is, then that company should not be subject to your foreign exchange regulations, which is not the case. The FEMA says, or the FDI policy says, that any indirect foreign investment, that is, if any company which has more than a certain percentage of foreign investment in it, if that company goes ahead and it's foreign owned and controlled, right? So if you have your ownership or control of that company, more than 50% of that company is owned by a foreign company, then that company, if it goes ahead and makes an onward investment in India, all the restrictions which are applicable to a foreign company will also be applicable on that Indian company when it's making an investment in India. By investment, because again, the idea is that when foreign money is coming into India, how is that being utilized is something which the government keeps a scrutiny on. And it's obviously the idea that all those foreign companies should not have control over these Indian companies which are there in the prohibited sectors. The difference also between, so this is what you call a downstream investment. When a foreign owned and controlled, which you call an FOCC, makes investment into another company, that's what's called a downstream investment. When you do, so also one other thing which you need to remember is the reporting requirements with the RBI. Now, as a lawyer, if your client has a foreign company, buys the shares as a primary issuance, so you are subscribing to the shares of an Indian company, the Indian company is required to do a filing called the FCGPR. The FCGPR, you have to do a FCGPR filing. If there is a transfer of shares between an Indian resident and a non-resident, then you have to do a filing which is called the FCTRS. So that FCTRS filing has to be done, which is a reporting requirement with the RBI, so that the government keeps record that even if you're making these investments under 100% investment route, you don't need the government's approval, but at least the RBI should know what is happening. So you have to file an FCGPR and FCTRS whenever there's a change in shareholding, foreign shareholding of the company. So whenever an Indian shareholder sells his or her shares to a foreign company, or a foreign company sells its shares to an Indian resident, or a foreign company is subscribing to the shares of an Indian company, In all these scenarios, what you need to do is that you need to do these reporting requirements, your FCGPR and FCTRS with the RBI. Similarly, in case of an indirect foreign investment, what the form you need to file is the form DI, which is for the downstream investment which is taking place. Again, your pricing guidelines which are there, which we initially discussed, are applicable even to a downstream investment, similarly as they're applicable to a foreign investment. And like we had discussed, what are the pricing guidelines? There is a floor and there is a ceiling. Whenever an Indian resident is selling his or her shares to a foreign company, what is happening? Money is coming into India. So the government puts a floor on it. So the government says that you cannot sell your shares to a foreign company below FMV, which is the fair market value or the fair market valuation of that company. Similarly, what the government does is that it puts a ceiling when the shares of a foreign company is selling its shares to an Indian resident, because at that time what is happening, money is going outside India, so the government wants to put a ceiling on it. So the government will say that fine, you can sell your shares to any foreign company, but you can buy the shares from any foreign company, but you can't pay the more than the fair market value of those Indian company shares to that foreigner. So the idea is that there's a ceiling on the amount of money is going. So pay them what is the valuation of the company, what is the fair market value which the valuer or your CA has come up with as per the following the mechanism, but not more than that. So those pricing guidelines are also applicable to a downstream investment. So you have to comply with all of these things. Then I think what we are then reaching towards is that there is an overseas direct investment as well. Now, ODI. What is overseas direct investment? Now, acquisitions or M&As are not only happening where the Indian company is being bought. Our Indian companies also go outside, they venture outside and they plan to buy companies outside of India. In which case, what happens is, like recently I did a transaction for somebody, for an Indian client who was planning to buy a company in Uganda. So they were planning to set up breweries in Uganda, for which we helped them out, right? Now, when you are in Indian company is applying outside of India, you need to follow the ODI regulations, which are the overseas direct regulations under the FEMA. Now, these say that any Indian company can buy shares of a foreign company, which is a bona fide company. Now, a bona fide company means that a company should have a proper business. So that again, the idea is not that you're parking money from India outside India in some shady business or any shell company which does not do any business at all. So in order to avoid that, what the government says is that you're fine, you can go outside and invest in foreign companies, but it should be in a business company which has a bona fide business. So if that company does not have any business at all, you can't just put a money over there in a shell company outside. You have reporting requirements which are required to be taken place. When all these shell company, all the ODI requirements, you have annual returns which need to be filed when you're making that. The government says that you cannot invest more than 400% of your net worth into a foreign company. So if you're doing more than that, you will require government approval. Or if more than 1,000 crores a year, 1 billion rupees, which is there, if you are actually investing in a foreign company, you will require the government approval in 1 year if you're actually doing that. So these are the restrictions that the government puts in relation to ODI investment, so that, and obviously all these investments will be regulated by the local laws which are there in that particular country or jurisdiction which is there. But in addition to that, you also have to figure from the Indian company's perspective whether or not they are following the ODI regulations. Now, ODI regulations are generally limited only to companies, Indian companies which are investing outside. For Indian individuals, the government has something called the LRS regulations, which is the liberalized remittance scheme. The liberalized remittance scheme says that any Indian individual cannot invest in his or her individual capacity more than 250,000 USD per annum outside India. If you are investing more than 250,000 USD outside India, if you are putting more than 250,000 USD outside India in a particular year, you need to take government approval for that, the RBI approval for that. Now, a host of transactions are allowed under the LRS route, which include you buying shares of another company, you're setting up something outside India, you're buying property outside India, or whatever you're doing. But what is the limit per individual per annum is 250,000. So a lot of times when people want to buy property outside India, or they want to buy property outside India, or they want to do something for which say it's a huge amount and 250,000 is not cutting it, and they're all individuals, so then they sometimes try and pool it. So within a family, 4-5 people will come together, they'll pool their individual limits and then try and buy that property out. Or you open a company in India, or you set up a trust outside India, and through that trust you buy the property. So there are different ways of structuring it. But when it comes to an individual in his or her own capacity cannot invest more than 250,000 per annum under the LRS route. ODI route is mostly for companies. Individuals are allowed to set up companies outside India under the ODI route, but you will have to adhere to the price cap which the LRS sets out for you, 250,000. Now, before we proceed and end this, the other thing which you need to know is when you're dealing with foreign companies, the other thing you'll be interacting a lot is something called the AD bank. The AD bank is your authorized dealer bank. The authorized dealer bank is the bank which is in charge of your investments. So it's in charge of through which the money comes and goes. The RBI delegates a lot of powers to the AD banks to make sure that if money is coming into your bank account in India, or if money is going through your bank account and being paid outside India, you need to make sure that it's being done for a legitimate transaction, and you will not allow it only in the first place for that transaction to take place if it's not within the legitimate routes which are there. So the authorized dealer banks also become very important for us. And whenever we're doing all of these foreign filings which are there, the LR, your OD, or FCGPR, FCDRS, or all these other filings, you require the help of your AD bank when it comes to that. So the idea is to keep the last 14-15 minutes to take all your questions. I think the first session had a lot of questions. We've not had many over here right now in the second session. So the floor is open. Any doubts about all the laws which we've discussed right now? Because tomorrow we'll be all practical. We'll be discussing practically how you do a due diligence. We'll not be going into the law which is there. I'll be discussing what are the practical things you see in a due diligence report. What are things you should look out for practically in every section? What is a due diligence report? How do you draft a due diligence report? What are the issues that you make? And obviously drafting of agreements, how do you draft it? What are the different type of clauses? There are things called reps and warranties. What is a representation? What is a warranty which is there? Why do you have reps and warranties in an agreement? If you breach a rep and warranty, what is an indemnity clause which is there in an agreement? How do you go about an indemnity clause? And does that indemnity mean a blank check that you can ask any money anytime? Or are there any restrictions or any limitations to liability as part of that indemnity? How do those link with your due diligence exercise? Because then there are things like conditions precedent, conditions subsequent, which come into place, and there are specific indemnity matters which come into place, all of which come into place from our due diligence exercise, which help us decide whether or not to buy the company. And if we're buying the company, on these conditions which are set out. So yeah, all of that tomorrow is practical. So from the legal aspect and on the general, discussions that we've had right now, if you have any questions which you want to ask, yes, the floor is open. Yes, Ajit.
Good afternoon, sir. Congratulations to your phenomenal success and for assistant lawyer. Sir, from your growth story, I can see in a short span of 6 years, you have achieved a lot. And in a year or a couple of years, you are maybe top partners of the Khaitan companies. So from your story, I can just eager to know that what are the top skills which being a law student, we are in the very early stage of our law school. So I just wonder what are the top skills which must be acquired before completing our degree and as an expert.
Be open to hard work and be willing to learn. There is no rocket science in what we do. There's nothing. I'm telling you, these are laws, right? There's the Companies Act, there's FEMA, there's everything. You will read the laws, you will know the laws. Yeah. Be willing to put in that hard work to learn. A lot of things, what will happen is practically as you go along, you will learn a lot of things on a daily basis. Every transaction you'll have commercial negotiations, you'll have a lot of these things. This means you'll be learning a lot. Be willing to learn and be willing to put in that extra hard work a few hours in the first few years. See, the legal profession is such that every year, there are law faculty, I think, passes out what 700 students in the entire law faculty every year pass out as lawyers. So there are a lot of us out there. So the idea is that to just put hard work, and there is, the legal profession nowadays, there is a lot of work. Like I'm telling you, Khaitan, we've been hiring at a crazy spree in the past 1 year. We've really increased our intake. We've doubled the number of members in our Delhi office because there's so much amount of work which is there. And what we do, and nowadays, like I have started sitting for the interviews also, and we part of the recruitment process. I'm sitting in the interview committee and taking interviews. What we look at is specifically, see, we don't expect that an A0 who's joining us, a fresher who's coming to us through a PPO, or if we're taking somebody for an internship, will be somebody who knows each and everything. What I've always been told is a lawyer is not one person. A good lawyer is not one who knows all the law, but he or she at least knows where to find the law. So you should at least know that if today I'm presenting you with a problem, which are the laws that you are required to look at. So that's what we're trying to do here also, to give you an idea about what all are the acts which are there, what all are the different laws which are there. So tomorrow, if I come to you, you're interning with me, and I tell you, Ajit, what the problem which is happening is that this company is investing in me, so you have to do the research. You should at least know where to find it. You have good research skills, you will be able to find what is there, but you should at least know where to look for. So that, please know your Companies Act if you're looking for corporate law. Know your basics of your Companies Act. Know what is there. Know what are director liabilities. Know what is a lot of people who come to us and I ask them what is the difference between a public company and a private company. They're not able to answer that question. Now, for that raises a red flag for us, because basic things you should know. You should know that there is a company. There is a private company and there is a public company. What is the difference? The Companies Act sets out things. So what you can learn as a college student is your theory. So know your theory there. And when you're doing your internships, try and learn as much practicality as possible. But obviously, because most of it you learn on the job, So there is no clear-cut idea that do these 5 things and it works out. But yes, be willing to learn and be putting a hard work. I think there's no replacement of that. And I can assure you, nothing that we do as lawyers is rocket science. It is nothing that, only A can do or only B can do. Everybody can do everything. You just need to apply yourself to it. It will not be an issue.
Yeah, definitely. Thank you, sir, for explaining that. So you all and your company have most number one law firm also. Do they provide any research assistance in the M&A group?
Is it only in my end, or is Ajit's voice getting cut?
So the voice is a little it's a little hazy. I think it's not clear. Ajit, could you please repeat your question?
Yes, sir. In short, I just want to know, sir, do you and your company, the Khaitan company, provide any research assistance in the merger and acquisition team?
Research internship.
Assistantship.
There's no research assistantship. So we have internships.
Yeah,
so when you have an internship and you're interning with us, obviously in the part of the corporate team, you will be exposed to the M&A exercise. We will take your help in asking you to do research for us. We will ask you to go to the MCA and pull out documents. Now, one thing you should all know is that all the documents, whether it's a private company or a public company, there are a lot of your public filings which you make, even for a private company, which are all available on the MCA website. Every company is mandated by law to file its financial statements with the MCA. Now, those are publicly available on the MCA website. You have to pay a minimum fee of 100 rupees and you can access those documents. The idea is to give you, and that gives you a proper idea of what is the financial condition of the company and what are the red flags in the company which the auditors have fixed up. A lot of these things. So you should know that the MCA website allows you access to a lot of the documents which you have to. So any document which you are filing with the ROC, or the Ministry of Corporate Affairs, that will be available on the MCA website for that particular company, even if it's a private company. So I would expect you, if you're interning with us, that you will be able to pull out those publicly available documents which are there. I will expect you, if you're interning with me, that you should be able to do your research properly. Your research skills will be good, because obviously it's not like if you're an intern, I'll make you do an entire transaction by yourself. I will need your assistance in things like, this is a proposition which is there. Please help me find some case laws on it, or please find the laws which are relevant laws which are there. So your research skills should be good in that. And obviously you should know your way around your basics, like the MCA website, how to operate it, etc., etc. And again, that's where knowing what to look for comes into the place, because a lot of these things are time bound, right? Somebody will call you and say that, okay, if can you find this for me in the next 3 hours, or can you find this for me in the next 2 hours? If you don't even know where to start from, you will be struggling. But if you know your basics right, then that will help you give a start point. And always, if you're interning, please ask the person if you have any doubt. It's better to just clarify it upfront rather than giving them something 2-3 hours later which is of no use to them. So that will always help you do that.
So if you would just allow me a minute
Okay,
to
thank you,
promote
sir.
PAC here. Ajit and everybody who's joining in who wants internships, not just Khaitan and Company, we bring in a lot of firms wherein you can get internships. So I hope that you have registered for the current academic session. First years, I request you to register again next year if you have missed out this year. And hopefully you all will be building a good base with M&A practice. And so we had 2 more questions. I think Uday was one, and
Mohammed is
Excuse me, ma'am. Excuse me, ma'am. From where we can register in the PAC so that
Ajit,
we can get updates on the internship?
Ajit, I'll personally text you. We'll take up the questions right now, but I'll personally text you.
Yeah, please do it. I think your PAC does a brilliant job. They've also been able to
Definitely,
get us at Khaitan enter into a long-term internship program with the CLC. So we'll be taking 3 to 4 students every year on long-term internships, which accumulate into paralegalship or accumulate into PPOs given with Khaitan. So yeah, we are doing it. So a lot of these firms are doing it, and the PAC is there. So please register yourself with it.
Thank you, sir.
Yeah,
Yes.
thank you, sir. Thank you, ma'am.
Yes, so we have 3 more people. So we'll start with Mohammed, then Uday, and there's one more person. I can't see the name.
Hello, sir. So my question is regarding not the topics that we have covered so far, but the thing is, recently I have been trying to research on the merger and acquisition laws relating to UK, UAE, and USA. So
Okay.
it is related to some. I was trying to write an article on a comparative analysis of our
That's
laws and UK, UAE, and USA. But the thing is, US, I'm pretty finding very difficult on that updated versions of this current, the current status of that this law in UAE, like their UAE competition law, their current status, and their corporate commercial law, like that. So do you have any suggestions or any other sources, valid resources that we can rely on to get these updated?
So US law is still easier to find. I think there's a lot of public, in domain which you can find when it comes to US M&A.
Yeah,
I
yes,
would
USA. Yeah, even I found USA a
Yeah,
little bit
that's
easier, but
yeah, because it's everything is in public domain. There is a lot of articles which are written on it. There is a lot of discussion which is there in public forum on it. So that's easier to find. UAE law, I would have to figure out where you can get the best thing for UAE, because I think again it's not very structured as there are no websites where one government website which will set out everything in one place as an updated thing. So I think what I'll do is I'll get back to you on that in UAE. What I can do is that I know somebody who's working in a law firm in UAE. Maybe I can just get in touch with them to figure out what's important for you. What exactly do you want?
it is basically the like as we have discussed the law regulating hours as like company law and competition law and all these laws. So a basic, I'm not drilling into very deep, but at the same time I just want to know a basic understanding of all the current.
I'll look for it if I find something which is related to this, and if there's something ready-made material which is available, I'll share it with Arushi at PAC, and then you can get it from PAC.
Sure. Thank you.
So if we can answer this question, Pankaj is asking if we can circulate the PPT. So if it's fine by you, can we circulate the PPT?
Yeah, you have it with yourself. Please feel free to circulate.
Right.
And okay, Uday.
Yes, good afternoon, sir. Am I audible to you clearly?
Yeah, audible.
Okay, sir. So, sir, I just wanted to ask you, since it wasn't that long ago when you yourself were a student at CLC, I just wanted to ask you from your own personal experience when you were a student, how you navigated to build a career in, say, in corporate law, given that there is a bit of a inclination towards litigation in our college. So how exactly did you navigate yourself through internships, etc., towards a career in corporate law and then M&A in particular?
So, very frankly, all my internships when I was in law faculty and CLC were were litigation internships. Even my internship with Trilegal was with the litigation team. After I finished law, I came to know that there's this firm, Indus Law, which was hiring. And so, I at that time, because in CLC, everybody does litigation. In my mind also, I thought that, okay, maybe I'll give litigation a try. But so when I finished law and I came to my knowledge that there's this law firm, Indus Law, at that time it was in Noida only, that which was nearby my house, that they have a place open and they're taking for internships, the job application therefore. So I applied over there and I went for an interview. They asked me basic legal questions about what I had done. And I answered all my legal. I had read up the Companies Act at that time, and I had done my basic research on what is FEMA and what is FDI and everything. And I gave a good interview. And as things would turn out, I ended up getting a job offer over there. Initially I thought that I'll do corporate law for say 2 months and see what's it about. But once I started doing it, I started liking it. Then seemed like maybe I was good at it also. So yeah, I mean, those 2 months that I initially thought in my mind turned into 2 years and now 6 years and so long. But yeah, I never did a corporate internship when I was in law school. I only did litigation internships. But yeah, but not that I'm saying that's a template. You should do corporate internships. But yeah, I'm just giving my personal experience on it. But because what I'm trying to say is that there's nothing set in stone in life. I mean, there is nothing that if you've not done it in college, you can never do it later. Or if you've not done it in that, it's just try and look out for opportunities. The college provides you opportunities. Take whatever opportunities are there. People are coming to your college for, recruitment. They're coming for internship opportunities. Figure out what are the criteria they're looking for. Try to work for those criteria. Make most of the opportunities which you have right now. And even if, say, ultimately PAC is doing its best and everything, and we are also trying to collaborate more as an alumni association with the PAC. But, in anything else also, we have a lot of alumni network which is there. And we are always willing to help at least, people who are there. We can help out people from CLC. So if you feel that at any point of time, there is a certain lack of opportunities, and this is after you've extinguished everything which is the college is offering to you, because there is a lot of things which the PAC offers you and everything is happening to you. And if there is something, they're always happy to help out. But yeah, what I'm just trying to say is that nothing is etched in stone. So it's not like if you've not been able to do something as part of college, it's not something you can do ever. I mean, that's what I'm trying to say.
Okay. Thank you. Thank you so much, sir.
Thank you. Next.
You can ask your question, and then I think Shabazz has his hand up. So.
And Anjali.
Yeah, and Anjali. Anjali, you can go ahead with your question, I suppose.
Okay, so my question is concerning actually the previous series that we had. So you mentioned business acquisition, sir, and you mentioned what is called as a slump sale. Correct. I wanted to clarify quickly what happens to, let's say, the human capital, because according to what you've been teaching us, that in a slump sale, parts of it get allocated to the merging asset or the merging company. And so I just wanted to know what happens to, let's say human resource asset or human capital. Do all employees get transferred, or is there a nullification to that? And I'm so sorry, I just had one more question.
Yeah.
Slightly digressing off the topic, but I just wanted to know. So I've been studying this thing called administration. It's happened in the UK with Vijay Mallya's company. So I just wanted to know, for companies that declare insolvency or bankruptcy, is mergers a possible step before they declare themselves insolvent? Could that be something that could be considered while declaring insolvency, or post that or pre that? I mean, I'm not sure of this stage at this point.
No, okay. So Anjali, we'll take it one step at a time. So firstly, just to answer your second question first, that you're asking. So when you declare insolvency, either there is one way. the one way is that you are self-declaring and you're going for a voluntary liquidation as part of a company in India. Or what is happening is that you are being driven into insolvency by your creditors. So anybody who's an operational creditor or someone else to whom you owe money, and if you've defaulted in that payment, they have a right to drag you to court and through an insolvency process, which is then a court-driven process in which the court appoints a liquidator and that liquidation process takes place. Voluntary liquidation happens is if, as a company, you go and you file for liquidating the company. But to do liquidation also, for voluntary liquidation, you will have to be, you actually have to give a statement. Your directors have to give a statement that pursuant to this litigation, to this liquidation, you will be able to pay off everybody's money. As long as you can't give that declaration, you can't voluntarily go into liquidation. Then somebody has to drag you to it. As opposed to the UK thing, which you're saying as an administrator, over there, what will happen is that once your company goes into liquidation and you go into administration, there's an administrator appointed, and from the next day, it's not your headache. That administrator will look after everything. But that's not how it plays out in India. The insolvency regime is different. Now, whether or not you can go for a merger, there is no law which says that if your company is bankrupt, you can't go for a merger. But all it is there is that if tomorrow creditor drags you to court and files an insolvency petition against you, and which is admitted by the court, and then an insolvency proceedings start, it is up to the liquidator to see what is the best way forward. Now, in that case, when somebody will come up with an offer to buy a company or will come up with a proposal to buy the company, then it's up to the liquidator to figure out which is the best way forward, keeping the interest of all the parties or all the stakeholders in mind. So so there's no law which prohibits you to do it, but then you'll have to do it before somebody sues you for insolvency.
All right, sir. Thank you.
Thank you. Yes.
And about I'm so sorry to interrupt.
Oh, sorry, your first question got
yeah.
Human capital, right? So like I said, so when you are buying a company as a business on a business transfer, now again, like we discussed, the two types: an asset sale, when you're cherry picking the assets, or a business transfer. Now, when I'm doing a business transfer, then I'm buying the business on a running basis, right? On a running basis as a going concern. In which case, what happens is that you take over all the employees, and all the employees then get transferred into your payroll. So, and that happens on a continuity of employment basis, that all their gratuities and all their leave encashments and all their other employee benefits, they get transferred to you, right? So you get all those employees over there. In an asset sale, it is possible for me to cherry pick and say that maybe out of these 100 employees, I'll only take 50 of those employees, right? So we are only 50 of those employees. In which case, I will get those 50, the other 50, because see, the company is not shutting down in that case, right? So those 50 employees can remain in the company, and I only take over those 50 employees. Now, those 50 employees, they can come to me in two places. So either they themselves tender their resignation and then do a clean employment, fresh employment with me, or they're terminated by their current employers and then I offer them an employment. The second thing is avoided, because if you terminate any employee, then basis on the category of the employee that is there are labor laws which require you to pay any retrenchment fee to them or any severance pay to them. So you don't want to get into all of that. So that technically how we structure it is that we tell those employees that we are giving you better terms in our company. So you please tender and we are buying over these assets that you're working on. So you tender your resignation with this company, and we'll offer you fresh employment with us. So that's just a cleaner way of doing it.
All right. Thank you, sir.
Thank you, Anjali. Yes, Shabaz, you've been waiting for a long time.
Yes, sir. My first question is related to Flipkart Walmart deal, where the FDI policy was changed while the M&A, while the deal was happening, I guess. So changes in such rules and regulations during the M&A process, how does it affect the deal altogether?
So it depends on the law itself. Mostly some laws have a retrospective effect, and some have a prospective effect. Now, whenever a law is passed, it will say that this is applicable from X date, and any transaction which has already been taken place or already been approved at that date will continue to function as per the old law, but anything happening which is filed after today will be as per the new law. So laws, if you see, and as part of the interpretation of law, when you see it, every law has a grandfathering period, or some laws, they give you this retrospective effect, or some laws say that starting from today, you have a period of 6 months to rectify anything that you've done. So it comes from a law to law perspective. But if I am currently discussing a transaction, and we've not gone ahead and done anything about it, and the law changes, then the law changes. Then you have to follow the current law. You can't say that because I started negotiating something with you when the old law was in place and now there is a new law in place, I will not follow it. But when it comes to a merger, if your NCLT petition has already been filed, if you're already in the court process and you're about to be finalized, then sometimes what your act in itself will mention, the law or amendment, that what is the effect on these ongoing cases. And if it's not the case, then it's open for interpretation and it leads to a lot of confusion. But yes, mostly the laws will make it clear whether or not they have a retrospective application, or is it for anything which is filed going forward.
Sir, in this particular deal, Walmart is being investigated for FDI violation when the FDI policy was changed during the deal itself, I guess.
No, but wasn't this the case that they were firstly about to sell it to them, then they went ahead and sold it to someone else? So I'm not that clear on the facts on this, but it's definitely not because. What is your understanding? What you're saying? Sorry.
This FDI policy was brought in when the deal was in progress. Then now they are being investigated by ED for violation of FDI policy itself.
Because they would have see, I'll tell you. So when you are buying these things, so like I said, there are certain prohibited sectors and there are certain sectors in which it is allowed. So if you are, I think what they were doing was that they were doing multi-brand retail. And multi-brand retail, till some point of time, there was a restriction in FDI, which was then further relaxed by the government. I think the confusion must have been coming over there. But generally what I'm telling you from a merger and acquisition perspective is that every law has a provision which says that one is the applicability. Is it that all the previous transactions also have to follow this law? And in which case I'm giving you 6 months to actually correct everything in accordance with that, or anything from now on, which any transaction that takes place has to follow it. For example, the government had recently changed the digital media rules. Before this, all these digital media aggregators which were there, they were not, there was no restriction in the foreign investment which these companies could have. So you had InShots and you had a lot of these other digital news media players who were there, who were actually providing you with a lot of news. But then the government said that even if you're a news aggregator, you fall under the definition of media, and we have a restriction of 26% FDI on you now. Now, obviously, there was a lot of confusion into relation to it, that what is the application. Now, people who've already invested in these digital media companies, who own 100% of these companies, what will they do? Are they non-compliant on day one? What will happen to their investments? So how is it happening? Because now the transaction has taken place. I've acquired this company, 100% foreign investment. And now you're coming and telling me that this is not allowed in India because the law has changed. The FDI regime has changed. Then the government came out with a clarification. It said that all the companies which have already bought it, we are giving you a period of 1 year to rectify your shareholding, to make sure that it's 26%. Or if you want to continue holding 100%, you have to take governmental approval. And for that also, we are giving you a period of 1 year. So it is only if you've not been able to do this within a period of 1 year, that after that, you will actually be held in contempt of the law. So, I mean, a lot of times, sometimes we just come out with things which are not, the law comes, which is not clear enough, and it leads to a lot of confusion, and it helps lawyers a lot because then we are given money to interpret it for the clients. But otherwise, yeah, laws in itself come with this distinction.
So that was my confusion, that at what point or on what date we can say that the deal has been signed and the law on that particular day would be.
I'll tell you. That closure of a deal If I've bought a company is when I've made payment to you and you've transferred the shares of that company to me. Or in case of a merger proceeding, the merger takes place the day the NCLT files an order approving the merger. Correct? So that is when the deal takes place, when you've actually bought the company. If the only thing that I've done is I've signed a document with you and I'm yet to give you money and you're yet to transfer the shares to me, then that is obviously not, the transaction is not. So the language which you'll use as a corporate lawyer is closing of a deal. There's an execution and closing of the deal. So closing will only take place when the money is transferred and I transfer the shares to you.
Thank you, sir. Sir, and the last question, I just wanted to have the idea of what is the scope of due diligence that we do. Like, for example, this was going on my mind that if we go in depth, then
tomorrow's entire session, we have an entire session on due diligence tomorrow.
Yes, sir. So whatever we have discussed, obviously we are going to do that due diligence of that. But if we go in detail, like income tax rules, so a company's plant and machinery, it might not be doing the valuation of assets and depreciation according to income tax law. So do we also consider those things in our due diligence?
So those are generally looked after by the financial advisors. We as lawyers, we try and avoid getting into the numbers which are there. So we have a tax team. See, generally, so we have an M&A team, but we also have a direct tax team, which is a separate team in Khaitan. So all the taxation related things are looked after by the tax team, direct tax team, where we have qualified CAs also who are sitting with us.
Thank you, sir.
Thank you. Vishwapriti, how is the estimation of value of synergy done in a merger? It's again commercial, right? So you have to see that what value you're buying, whether or not it's worth it or not. And at what value are you planning to buy? Your valuation reports are made where you have your accountants and your CAs and your investment bankers sitting and doing valuation basis the past business of the company, the future the future projections of the company, what is the discounted value of all the assets of the company, etc., etc. So a lot of these parameters are taken into place while coming to the valuation of the company. Yes, Mohammed, your question.
Yes, sir. So I was just going through the recent happening that is between the Z and Invesco that is going on, and I just saw that a recent update that Z has moved to High Court against the Invesco's demand for EGM, and that notice to be declared illegal. So, according, my question is like, what is your opinion, or like, what would be the way ahead? Like, first, the NCLT has asked Z to convene EGM according to the request by Invesco. All this happened after a merger as well, like a merger announcement has been
announcement. So announcement is different than actually taking place. Now, so once announcing the merger is different, and then for you to actually follow through with it, you'll have to follow the procedure which is there.
Okay, so regarding this High Court, I mean, what would be the way ahead according to your point, I mean, your experience? What would be your thinking that Z has moved?
Again, the idea is that if you've gone ahead, so you have to take the permission on a merger. Like we said, that for a merger to be approved for the NCLT, you require the approval of a minimum of your 75% or more of your shareholders, which are there, and your creditors. Correct? So if that approval you don't have, and if your shareholders are withholding that approval, and if they call an EGM, then you have to, everybody sits and the shareholders are not giving you that approval, then your merger will get stuck.
So this indicates that probably this merger deal will get stuck in between, right?
No, but if that would have to be, that was more than 75, more than 25% people will have to object to it.
Okay, but at the same time, this Invesco was one of the important stakeholder in the, I think.
I don't know their exact percentage. Maybe tomorrow you can just read up the exact percentages and then we can have that discussion.
Sure, sir, sure. Thank you. I just got to see and like to have your view. That's all. Thank you.
No, perfect.
Right. So I think Sir could take more questions tomorrow. It's been a long day for all of us. A lot of information for us to go through and process, and then come back tomorrow again, fresher to take in more information.
Yes. Just 2 more sessions to go. Don't worry.
So we're halfway there. there is like another half is left. But still, thank you so much for the session today, sir. We'll wait for tomorrow. And I thank everyone who has joined in, and Sanya, my team member, who was there coordinating the presentation. Tomorrow's session will again start at 10:30 sharp, and similar pattern will follow, that 1 hour break and 2 sessions therein. We'll circulate the PPTs. Please drop us a mail at careerswithpac@gmail.com. Sir, any other information for tomorrow if you would want to convey?
I think like we've already discussed what we're doing tomorrow. So we are going to do your due diligence, transaction documents, reps and warranties, indemnities, and post-closing issues. Basically all the practical things which are there.